The militia are so important, they rank amongst 7, and only 7, institutions the Constitution specifically names and treats as permanent. These institutions, in order of importance, are we the people, the militia, the states, the United States, the Congress, the President, the Supreme Court.
The militia are composed of the people themselves, and they exercise the ultimate power of government, the power of the sword. So it's putting the militia at the very highest level because the Constitution does not identify Congress, the President, the Supreme Court, or even the states as necessary to the security of a free state or necessary to the security of anything for that matter. Only the militia are identified as necessary.
The militia rank alongside we the people themselves because the militia are the people. In fact, the people's very sovereignty depends on our control of the power of the sword through our militia. The astute citizen will note that neither the Army, the Navy, nor any department can claim a constitutionally mandated existence. Nor can they exist at all unless Congress specifically acts. The militia, on the other hand, exist whether Congress acts or not.
Who wants to be governed? Nobody. But we all want to be protected, don't we? And the purpose of the American Constitution, if you read it very carefully, and the Bill of Rights in particular, is not to govern the people, but to protect.
The Constitution does not recognize a militia of the United States.
And it's because of this unconstitutional act that Congress passed, Title 10, the militia of the United States. There's no such thing as the militia. It's unconstitutional right on its face. They are state institutions, and prior to the state institutions, they were colonial institutions. This is 300 years of historical as well as statutory history there.
The President may only call forth a state militia for the 3 constitutional purposes, and the Governor is under no obligation to accede to such a call if he feels the mission is unconstitutional. Militia deployment is yet another check and balance the founders built into our constitutional system to prevent the federal government from usurping power.
The whole idea of the militia was to protect the states against the federal government. It was to be one of the very serious, tangible checks and balances against a federal government that might conceivably grow beyond the limits of what are in primarily Article 1, Section 8 of the Constitution. There are only about 18 things the federal government is supposed to do, and a lot of the rest of what we have going on in Washington simply is not constitutional.
Because the Constitution guarantees the permanent existence of the militia as integral elements of the balance of power, the President, the Congress, the Supreme Court, nor any state can disarm them. For disarmed militia are no militia at all. Thus, if Congress, influenced by some gun control lobby, neglects to provide appropriate arming of the militia, as stipulated in Article 1, Section 8, Clause 16, the states must arm their militia anyway and take legal action to thwart any unconstitutional legislation passed under the influence of the gun controllers.